Have you ever wondered what to look for when you're seeking out an immigration attorney for your EB-5 process? If so, this is the video for you. Hi, my name is Isabella, and I'm the program manager at the American Immigrant Investor Alliance. We are a 501c4 nonprofit advocating for the rights of EB-5 immigrants from across the world and advocating for transparency and equity in the EB-5 process for all. So I have the privilege of speaking with 4 of our partnered immigration attorneys. Thank you guys so much for being here. We're here with Rana Jayazerli of Klingner Jayazerli, Dennis Tristani of Tristani Law, Benjamin Hugh of the law offices of Benjamin Hugh, and Michael Harris from Harris Law. Thank you guys so much for being here. I would love to go around the room and get 1 or 2 lines about yourself, your firm, and your practice. So Rana, if you want to start us off with that.
Hi, my name is Rana Jayazerli, Klingner Jayazerli, here in the Washington, D.C. area. It is immigration law practice. I've been practicing immigration law exclusively since 2007. We handle all matters of immigration law, business primarily, business law, and EB-5 investment law. I've been doing EB-5 investment law since 2007, representing individual investors, handling I-526 petitions, now I-526 and 526Es, which are for investors who invest in regional centers. Also handle representing regional centers and their filings, but our primary focus are representing the individual investors.
Hi, everybody. Dennis Tristani, Tristani Law, based just outside of Washington, D.C. in Rockville, Maryland. I've been practicing law since 2012 and practicing immigration law exclusively since 2012. My practice focuses primarily on business immigration, family immigration, and within the business immigration sphere, EB-5 investor visas, which I've been working with since 2013. My practice primarily focused on investors from India, Asia, Latin America. I speak Spanish fluently, Portuguese, and over the years I've helped open offices in India and Latin America for other firms that I've worked for, primarily focusing on the EB-5 market. And very happy to be here.
Thank you, Isabella. My name is Benjamin Hu. I've been working in the EB-5 sphere since 2012, and I've been running my own firm since 2019 with a focus on EB-5 and other broader business immigration and also family immigration cases. I speak Mandarin Chinese fluently, a little bit of French, a little bit of German. And for 3 years in the 2010s, I was also posted out to Guangzhou, China, where I was opening up a satellite office right outside of the US consulate to manage the EB-5 IVOs and immigrant visas.
Hi, everyone. My name is Michael Harris. I am an immigration lawyer based in Miami, Florida, where I've been practicing law since 2007. I've been practicing immigration law since the start of my career. I've actually worked in the field of immigration law for now over 23 years. I got involved in immigration law out of college, working for a board certified specialist outside of the University of Florida. Today, I'm a board certified specialist myself among around 80 attorneys here in the state of Florida that are certified as specialists in the field of immigration law. I practice mostly these days in a business and investment-based immigration, including the EB-5 program since the start of my legal practice in 2007. I've been operating my own law firm for over 11 years now. Today, I'm also a member of the Florida Bar Board Certification Committee on Immigration Law. And with that being said, my specialty really in immigration law covers any area that I choose to take upon, but pretty much mostly today, EB-5 investment and business immigration cases for employers and employees and entrepreneurs here in the state of Florida and Miami.
Fantastic. Well, thank you guys for giving those little intros. For everyone, these attorneys have worked with AIIA for quite a long time, and they have consistently demonstrated their record for protecting investors' interests and advocating alongside AIIA for the mission of making the EB-5 process more equitable for all. So they are truly investors first attorneys. Let's just hop right into it and start talking about why EB-5. What made you stick with it? What's impactful about the program that has made you keep practicing since you started getting into immigration law?
I personally enjoy the clients. I've been fortunate enough to travel around the world. I've worked with EB-5 clients from Asia, from Latin America, Europe, Canada, and just being able to meet clients that are truly exceptional, that are in a position to contribute to the United States. And because the EB-5 process, to be honest, is so long. Currently, I've had many of these clients, for 5, 6, 7, and 8 years, and they're just wonderful people. So I think for me, it's the clients that the reason I keep practicing.
For myself, since I have a background in immigration law before I went to law school, where I became heavily involved in high volume corporate immigration and business immigration. And once I got exposed to that, due to my own family's, my father's involvement in the marketing of securities investments for 20 years at the end of his career, it sparked an interest in me to also consider what a financial investment security was. And that eventually led me to EB-5 as I started to practice law. And for me, given my own personal experience that I've had with some of those areas, things that I've seen my family go through and choosing investments, choosing the wrong investments, and suffering the consequences of that has really been, one of the things that drove me into doing EB-5 and enjoying it for different reasons. There's the investor aspect, there's the capital raise aspect of helping projects get structured properly to be able to raise investment capital. So for me, it just, and also with someone that almost became an architect or engineer, became full circle when I started to be able to help projects and, construction and engineering projects like this develop from a different way.
For me, one of the big draws of EB-5, it goes beyond the standard immigration job satisfaction, where you get to interface with a human life, a human narrative, a family that you're bringing over to start a new life in America. It also strikes me as being a very morally compelling category. We are bringing across some of the greatest entrepreneurs and some of the greatest business minds from other societies to come to America, to bring lawful funds to America, and to create 10 jobs, long-lasting jobs in the American economy. That to me just strikes me as a win-win situation. And so it's one of these categories that I think has been resoundingly successful in the immigration US pantheon ever since its inception. And I hope it will be with us for a very long time. And I hope it will continue to make America strong by bringing over the best of foreign entrepreneurs.
There's a lot of people who will say, oh, well, why would somebody who has the ability to invest, $800,000 want to even immigrate to the United States? And what I have found is consistently for any of my clients, when it comes to immigration, no matter what category that they may be, whether they're an individual coming as a student or, been sponsored by family or work or by EB-5, it is always the same thing. They're coming because the opportunity in the United States is something that is greater than the opportunity where they're living. And oftentimes when it is under the EB-5, they're doing it because for their children, the opportunity is greater. And they find that, yes, they may themselves, have found, they may have accomplished and reached a point in their lives where, yeah, they have $800,000 that they can invest. But their children, because where they live, may not have the same opportunity to reach that point in their lives because population, crowding, the universities just don't have that kind of space, or the political climate is one where they don't feel that they can trust the government situation or the institutions. So the United States is still the same place where, we have opportunity. It's the land of opportunity. And yeah, we have our growing pains and we have our ups and downs, and, but we are still the United States. And we think that we are always striving to be the place where, people can be anything that they strive to be based on their inputs and their abilities and how much effort they make. And so that's why people still want to come here. And EB-5 is that opportunity to do that based on your own initiative. You don't have to be sponsored by an employer. You don't have to be sponsored by a family member. If you don't have those options, you can do this because you have the ability.
Right. That's actually a great point. I feel like one of the things that's often left out of the conversation on EB-5 is, even though it is an employment-based visa, there are no qualifications besides being able to invest those funds that are required of you. Like there's no English requirement. You're not required to have a certain level of, skills to opt into it. It's essentially open to everyone, barring the material input that you have to put in. But okay, fantastic answers. Thank you guys. So I would love to segue into when we're talking about selecting immigration counsel. I know that there are plenty of prospective investors who are looking to opt into EB-5, especially after the Reform and Integrity Act put the set-aside categories out for new investors to take. So when we're talking to these prospective investors, what qualifications or traits should they be looking for in their immigration counsel? How do they know what a good immigration attorney looks like, and what should they be looking for when selecting that counsel?
Experience, obviously, I would think, and there have been situations where I have actually, and I'm sure the others have mentored attorneys in the EB-5 area who don't have experience. And, that's not unusual because this is a very specialized area. So if an attorney doesn't have experience in EB-5 and hasn't done it before, this is not a particular area of the immigration law where you should try to wing it. Let's put it that way. So it's important that if you have an attorney, that attorney knows what they're doing in EB-5 and has done it before, or is working with an attorney who has experience in the EB-5 law and has done it before. It's constantly evolving. Last year, there was a brand new law, obviously, that was passed, the Reform and Integrity Act. But even beyond that, the Immigration Service, to put it mildly, they change, they can evolve in how they apply certain things.
State of constant self-improvement.
Yes, that very well put. Yeah, and so you just have to be on top of it, and you have to practice it on a regular basis.
Yeah,
to know what's going on.
Just to piggyback off of what Rana was saying, I would agree. The USCIS has put its fairly basic, almost minimal guidance up online in the USCIS policy manual that is publicly available. You can access it wherever you can access the US government website. In some countries, you may need to jump over a firewall to do so. But I would say it's a good read. It is also a fairly basic skeletal outline of what USCIS is expecting in EB-5. What is not included are the constantly evolving nitpicks, details, and their day-on-day iterations of how they're adjudicating. When you're speaking to a possible immigration attorney, it's a good idea to have gone through that and have a general idea about the structure and also have an idea about the certain phrases, and then watch your attorney, watch what they're saying. If they're just parroting those phrases back at you and not really moving the discussion further, it's probably a good sign they don't have a lot of experience in doing this. And it's up to you how much experience you want your attorney to have. But I'm also speaking from experience from the insurance forms that immigration attorneys fill out. You'll get a certain stack of papers if you want to do immigration law and you fill those out. And then if you want to do EB-5 immigration law, there's another equally deep stack of papers you're also filling out too. And I'm sure a lot of us are very familiar with them. What does that say? That shows that the immigration industry understands EB-5 is complex. It is one of the most complex categories around. And you don't really want a first timer or a dilettante handling your case, not especially when there's $800,000 on the line. But regarding the legal advisor and their familiarity with the nation of origin, especially for the financial documents, USCIS does seem to be approaching separate countries' financial document regimens with different approaches and different levels of scrutiny and different tailored questions. So I would encourage an EB-5 investor prospectively to find a lawyer who's familiar with their country's financial documents and practices. That's very important.
I would add that there are characteristics that you can look at to your attorney. There's some check the box things that you want to consider. One is, are they a member of the American Immigration Lawyers Association? All of us are, and that's also referred to as AIIA. AIIA membership, I think, is if you're not a member of AIIA, I think that's a red flag for any immigration attorney that you might be considering. Some people might, so those that are not AIIA members and that do practice immigration law, it doesn't mean that they're a bad lawyer, I think, but I think having AIIA membership shows that you're committed to the field. AIIA provides us a ton of resources to be able to live and practice immigration law on a daily basis, with case alerts, with subject matter updates, best practices updates, provides us with the ability to try to engage in liaison, which means that there are volunteer attorneys that work with the government that might be able to help us with things, or if those attorneys themselves are engaged with the government and provide us some of the latest insights about what is going wrong with USCIS, where EB-5 petitions are processed. So someone who's an AIIA member is something that's very important to find. Here in the state of Florida, we have one of the largest, probably the one of the most significant board certification programs. Not every state has that, so it doesn't necessarily mean New York doesn't have it, but Texas, California attorneys, North Carolina attorneys have that option. So it's something I look to. I'm speaking for myself, I guess, as being a board certified attorney for over 10 years and member of the committee that selects other attorneys. I think that's something you can look at, especially I look to in other states when I'm trying to find an attorney for a client who needs something to be handled there, for example.
I think one more thing I may add is that, especially with EB-5, right at the beginning of any EB-5 case, the investor is going to be really involved with the source of funds. It's the burden of the investor to provide objective documentation of where the investment funds are coming from. And depending on where you live, that may be complicated or it may not be. And so there's a lot of attorneys or EB-5 attorneys that may have more experience with source of funds from one country than another. So that's always a good question to ask if your attorney knows Indian source of funds or knows Vietnamese source of funds because they've had hundreds of investors from that country. You're likely going to be in very good shape when they're looking at your documents. They're going to know what to look for. The case is probably going to move a bit quicker, a bit more efficiently than if the attorney has never seen income documents from India or income documents from the Middle East, for example. And one other thing generally I would say, just to sum it all up, is you want an attorney that is communicative, that is quick to answer questions, that is quick to email you back or chat you back. I think that if you've been in communication with an email for 2, 3, 4 days and you haven't heard back, not that it's a red flag, but normally most attorneys should be getting back to you quickly if they want to work with you. And if they're not, if their emails are short, if you're not really getting good answers to relatively simple questions, then I think that's a red flag of what the long-term relationship might look like. And this is a rather long-term relationship. So.
And Dennis, I agree with you on experience, and Rana and Benjamin, there are certain things that you have to look to for a lawyer's experience. Like to just compare to myself, my experience started with EB-5 project work really, and a direct standalone project, and then regional center formation. And so, for me, I hold that out as because I started working with projects really before I started working with investors, and it's important, I think, to get a well-rounded EB-5 lawyer that has, and of course, today I've worked with many investors, but to have an attorney that has that experience on project development or regional center formation development, understanding those issues is key, because it can help an investor identify problems that might exist in the project, or for example, who the attorney might have been on the project. We're a very close-knit community in the EB-5 world, so many of us do know each other. And when I have an investor consider a project, if I don't know really who the attorney is, that might make me wonder for a moment. But generally, the reputation of those attorneys is very important, and I know, okay, that attorney was involved there. I feel pretty good about it. That attorney maybe structured it, or understanding what red flags are otherwise there, and how an EB-5 project works and doesn't work for different aspects like job creation methodologies.
Yeah, I was going to say, but I think people need to be careful that the attorney understands their role vis-a-vis a project, that they're not advocating or pushing or talking about the financial aspects of the project, that the role of the immigration attorney is limited to, just talking about the immigration aspects of a project, that when you're working with an immigration attorney, or when you're looking for an immigration attorney, I think I would be, make sure that they're not pushing any one project, let's just say, or that they're not, that they're not stepping outside of their lane, so to speak, unless they are an investment, broker, dealer, or something, which, there are, that's important too, that the immigration attorney is focused on the immigration.
That's actually a good point. I feel like there are so many investors who ask very often, like, can my immigration attorney help me find a project? And the answer is no, correct?
I mean, it should be, yeah, it's correct. That's not our role. I am not in any way an investment advisor. I don't know anything about investments. I wouldn't be able to tell somebody how, and I do get asked that all the time. And it's it's a difficult position to be put into because of course you're advocate for your client. That is your role. When you're the immigrant, and oftentimes you're the only advocate for your client because they don't have anybody else, but you need to encourage them to find an investment, a broker dealer. And there are many in the industry right now who focus specifically on EB-5 projects, and they can do exactly that. They can help them find, identify, vet projects, an important thing. And that is something that, you want your client to have somebody who's working with them specifically on that. We, as the immigration attorney, can say whether or not we think that there are issues with the project in terms of satisfying the EB-5 immigration requirements. And that's what we need to do.
Investors need to know that at least since the time when I really started to learn about the regional center program, which, while it was established as the regional center pilot program in 1992 and has been renewed for various amounts of time, and now it's extended for several more years. When I started to get involved in the EB-5 regional center program really heavily, probably in 2009 or so, and which was led by the financial crisis here in the United States, when developers really were looking out for better, inexpensive forms of capital. At that time, there really weren't a lot of regional centers. And I think other immigration attorneys, there weren't really that many that were available. Now today, if an investor simply Googles, they might see certain regional centers that are out there, very well-known ones. That makes the job a little bit easier for at least the immigration attorney to say, hey, there's only, in the old days, there were only 5 regional centers or so. And that was a different burden for those investors and those attorneys to really find those projects. Today, the market has evolved so much that the simple search by an investor might reveal some and some that are very problematic, and then an attorney might be able to say, hey, that one's had major problems. They're broker dealers that really have grown into the space, and really good track records of projects that are out there that we can try to look to. But like Ron has said and others have said, we're not investment advisors. We're not qualified to be able to tell you whether a project is going to succeed on the merits of the business in several years. We might be able to look at the job creation methodology, or whether it's had any major issues that we can ask about from the project with that particular project or the developers.
If your immigration attorney you've been speaking to says, I can absolutely introduce you to projects, I know which are the best projects, it's a red flag in my mind, only because, I don't want to say it's because they work with that one project or regional center lot, but it's probably that's probably the case. And as attorneys, we need to be impartial, we need to be objective, but we need to know our limits. And while we're not financial advisors, as Ron and Michael said, we can gauge immigration risk. That's our goal with an EB-5 project when we're looking at it. There's obviously regional centers that have been around much longer than others, and that's obviously a good place to start. As Michael mentioned, you can Google search nowadays, and you're going to get some of the top 3 or 4 that have, in terms of how long they've been in the market. But that's definitely something, you want to work with someone qualified. You want to make sure that you're getting advice from people who have vetted the
fact
project
that a regional,
financially.
I'm sorry, but Dennis, I just want to say, I want to make sure people realize just because a regional center has been around, past track record is not a guarantee of future success. And unfortunately, we've seen that too. So I'm not saying that isn't something you look to, but you need to keep that in mind too. It's just important for investors to keep that in mind. Each project is still a standalone project that has to be assessed independently.
Right, exactly. Each project, and you have different types of regional centers, some that are really just sponsoring projects and giving them the ability to go out and raise their own capital separately. Others are really lenders and have similar structures for all their projects, where they're just loaning money. But you can see again in Google, what lawsuits maybe have any project the regional centers have. There's a lot of information out there today. I think that helps, but there's a lot to go through.
Are the developer and the regional center one and the same? Is there an arm's length relationship between them? What is the experience of the developer in general? What is their track record? Things. again, I mean, there are a lot of due diligence. What is the due diligence involved with the regional center when they select the projects that they're going to? There's a lot of questions that can be asked and looked into. And again, a good investment broker or broker dealer is going to look into that stuff too.
So there is one thing I sort of wanted to ask all of you, because each of you own your own firm or a partner at your own firm, and these are more boutique law firms as opposed to a large corporate entity. So is there any merit to going with a smaller firm as opposed to a larger firm? And how does an investor judge between the two?
I would say many of the benefits are going to be organizational. So smaller firms tend to be significantly faster to respond. It is easier for them to give bespoke attention to each investor's specific and unique needs. Larger firm approaches can apply very well to scales of efficiency where the procedure is a sort of one size fits all or a universal procedure. I've found that EB-5 tends to be it tends to defy this type of approach a lot, because you're now accounting for a very large amount of money, and each investor has a separate story behind them, has a separate history and background and lawful source. So reactivity, responsivity is very important. Adaptability, flexibility, and creativity, these are all very important. And you usually get those from one single attorney or a group of tightly knit attorneys within the organization who've handled this category many, many times in the past, who can bring to bear the creative problem solving that you need.
Yeah, and I'll piggyback real quick. I was going to say something very similar, but I think, obviously the smaller firm, when I started my firm a few years ago, my goal was, to be able to work with the clients I want to work with, to be able to provide, tailored attention. I've worked at a bigger firm before and handled thousands of EB-5 cases over the last 7 or 8 years in a very high volume, fast-paced environment. I learned a lot, but the lines of communication definitely break down when the team you're working with involves 2 attorneys, a paralegal, a legal assistant. Emails aren't always coming from the same person, and while again efficiency is a big thing and getting the case done quickly is one thing, I do think EB-5 investors value the ability to speak to their attorney, to chat with their attorney, not 24 hours a day, but maybe 23 hours a day. In that sense, they really value, quick communication. And I do think that smaller firms provide that, just, based on the way they're set up and the way they're organized.
Yeah. I mean, I think when you work with a smaller firm, essentially you're working with the attorney you hired. You're working with the partner level. When you work with a larger firm, the partner will be the relationship attorney, the person you talk to maybe when they first hire them. But at the end of the day, oftentimes the people doing the work are the younger associates, and the paralegals. Now that doesn't mean you're not quality work or they're not doing, but when you're with a smaller firm, and you would say you hire one of us, we're the ones probably doing most of the work. We're the ones who are going to be the ones talking to you when you're, it's just a different, obviously, setup. It's just the way the nature of the firm is. So, it's a more one-on-one direct relationship.
And it's a long relationship too. It's not like something that gets done in a few months and then that's it, you get your green card. It's a multi-year investment with multiple stages and multiple forms. So having that one point of contact that knows your case, knows your family, knows your business is very important from start to finish.
I was just going to make the point that that's important too, because I've been in larger firms and I've moved, and my clients have moved with me. And I think because how EB-5 does evolve and move, having that relationship is important, because the process takes a while. And so when you have the relationship with your client, even though the process might take a while, the connection with the client stays, and they stay with you and you move with them. So that's important.
In my view, a boutique firm, a smaller law firm, I think has more flexibility on different things. Firm models, I think, in the larger firms that might not adapt very well to being able to, I think, innovate as well. In my opinion, the larger firms may have more ability to invest in different technology, but the playing field, I think, has shifted a lot over the years, where technology really is available to everyone. And so smaller firms are able to, I think, take advantage of, being able to innovate faster than some of the larger firms. It's always, I think, the boutique firms that are that end up getting bought by the larger firms because of that. There are different ways that a smaller firm can innovate more flexibility on different things with your clients. Even fee structures might be more flexible. I don't have to follow the billable minute rule that some large firms might require, where I have to bill for every amount, or to be able to get some type of flexible cost arrangement with a client who doesn't like that I need to bill for every single 5-minute call. There are different things that a smaller firm has that ability to do, and work with their clients on.
That's a good point, actually, and a great segue into our next question about the cost of opting into or retaining an immigration attorney. So when we've talked to members of our base, we found that most immigration attorneys that they're working with charge around $25,000 to $40,000 in legal fees for the entire EB-5 process. Can you talk a little bit about what factors make up the fees for retaining an attorney and what might influence between cases? Some
clients, they might view the EB-5 process in terms of quotes sometimes that I think some might provide depend on there's 3 principal stages to the EB-5 process. There's your initial immigrant petition. There can be your concurrently filed application for your green card, or that second stage occurs after your first part is approved, and then the third step to be able to remove conditions on your green card. When you take those 3 together, some clients I think might be receiving quotes based on all 3 of those together, which is one way to look at it. However, those 3 stages can occur over so many different periods of time, long periods of time, that I think it's better for an attorney to charge based on each of those different stages, rather than, for example, collecting a fee for all 3 of those stages. If an attorney does that, the questions would be, do they put that in their trust account? But those fees can be, I think, based on the amount of time that an attorney spends on a case, whether it's a flat fee or an hourly fee. It really can be different. I think the trend in the legal industry has really been to move away from billable hours. I know a lot of attorneys that still do it, and especially they're at Am Law 100 firms, very large non-boutique law firms, where they have to use the billable hour, and things get more expensive. So, those are some of the factors. How long does this process take before justifying whether or not that fee is proper or not?
I think that's right, and the complexity of source of funds is one thing. Attorneys will obviously take into account if source of funds involves a lot more paperwork than the norm, then an attorney may charge more because it's simply going to take more time to do. As Michael mentioned, there's 3 parts to the EB-5 process. The second part, or I should say, if you're filing concurrently, it's part of the first part. If you're pursuing consular processing, that'll come a little bit later. If you have a lot of family members, dependents in the case, everyone has their own individual application for consular processing, for adjustment of status. That takes more time if you have 2 children versus 5 children. So you may see higher fees for depending on how many people are in your family. And again, it's all based on the amount of work that's involved in the case. And normally, in the industry, it's very typical for the fees to be split up over the stages of the process, and the amounts of the fees to sort of depend on how much work is involved at each stage, because it is very different. And there's a lot more work that goes into the case at the beginning.
Yeah, the 526 or the 526E stage is definitely the most expensive for legal fees, because that's the most work intensive. And sourcing of funds, that's where the most variability comes when it comes to legal fees. Because again, as Dennis said, whether or not, source of funds, you could have multiple sources. And so then you've got multiple sourcing. You could, if it's a gift, if it's from several people, how many layers are there to the source of the funds? And so that has to be explored. And then if there are multiple layers and each one has to be sourced, then that has to be, what about the path of funds? People talk about source of funds, but path of funds also has to be tracked. And that could create, a lot of extra additional work, because people, when they get, they earn their funds, however, they don't sit on it necessarily in one account. change in circumstances, you might have a flat fee, and we do flat fee, but there has to be an understanding that if something changes or there's some, information that comes out later, additional fees might be charged. Or if a request for evidence comes from the Immigration Service because of unexpected information or something that wasn't anticipated, and not because of something, as the attorneys, we didn't address or failed to address, that can also lead to additional fees.
And I would also add that in the initial consultation, when you're speaking with a lawyer and trying to find out how much they're going to charge you, the lawyer's trying to find out how complicated your case is going to be. It's very important to be honest about everything. Attorneys are certainly going to try to find out if there are certain admissibility issues, like a prior criminal history, like prior unlawful presence in the US. Perhaps there was an accidental overstay or an intentional overstay. Even things like being a member of the government of the country that you're part of. Chinese Communist Party membership is a very common obstacle that has ways to get across it, but a lawyer needs to know about that to begin with. And I would also counsel investors not to be put off about being honest. It may potentially raise the legal fees if the lawyer is able to calculate, I estimate this much more work will need to be done, but the legal fees are certainly going to pale in comparison to the possibility of losing your $800,000 investment. So you want to be honest and open with your lawyer and find preemptive solutions to your problems from the get-go, rather than put it off and hide it and try to fabricate a solution later on when you're already a third of the way into the process.
And there is attorney-client privilege. So
Yes.
that's something that is critical to understand. If you share information with your attorney, the attorney cannot reveal that without your permission. That is a sacred privilege under the law, meaning the attorney could not be forced to testify about that information. Now, that said, if it's information that precludes the attorney from being able to move forward with representing you, then they won't. That's just under, but they will not and cannot reveal that. So if there is information that you need to provide, you provide it, because the attorney can't represent you to the best of their ability or to the best of your interest unless you provide that information. And most of the time, the information that you think is really negative is not, because the attorneys have seen it, heard it, done it. They can advise you and give you the best representation and probably offer you, the information solution and how to, work around it.
So one thing I'm curious about, because many investors don't really think about this when they're opting into their process, is what about attorneys who represent both the project, the investment project, and investors in that project? Is that something that people should be looking out for, and what considerations should be taken into account when working with an attorney who's doing dual representation?
First of all, dual representation is something that at least the bar rules in my state, and probably the uniform rules will speak of in many states, probably cover this. Dual representation is something that an attorney, if they're going to engage in, needs to be done so that all parties have informed consent and disclosures to them about that representation, the potential risk of a conflict of interest occurring. Those are very serious things. I think red flags are when you go to an attorney who has represented the project and then says, yeah, here, look at this project, and introduces you to it that way. I think that's a huge red flag. I don't want to alarm my clients, because I always tell them I represent a variety of different projects, but my preference is that you not look at those, because I know too much. I might have opinions that I formed about them, and it makes it hard to, I think, represent that way. Projects, if they market to investors and those investors don't know what attorney to do, many of those projects might give them a list of attorneys to consider. And if you represented them, I think you have to be very careful. The investor has to consider whether or not there's no bias there. I think when an investor is, choosing a project that their attorney also has represented, and especially if that attorney has financial interest in that project, that's even a huge, I think, major red flag if that's the case.
Immigration is very unique, and that dual representation is actually common. In family law, for example, almost always I represent the husband and the wife, for example, if there's a marriage sponsorship. It would not really make sense for each person to have their own attorney. So if the husband's a US citizen and they're sponsoring their wife for a green card, you're going to be the attorney for both. But that's dual representation. And you do have to make clear that you represent both, and that if there ever reaches a point where somehow the marriage breaks down, you cannot represent either of them anymore. Unless there's some sort of consent or waiver. For example, later on there's a petition that they have to also, kind of like the 829, there's one for marriage-based. Similarly, employer-employee. But the EB-5 is unique in that it's also got a financial element to it. So to represent both the project, right, and the investor creates an additional element and kind of dilemma for the attorney. And so it is complicated. So it happens. I've done it. I've been in that situation where I represented and then, they came in and they were investors. It's not a position I like to be in. It's not one I really do often. But if you do it, again, it's not unusual in the immigration world to do it. And you can absolutely represent both because, again, the interests are aligned and you might know the project better and you can represent. The issue becomes later if they ever reach the point where their interests are not aligned. What you never want to do, though, as the immigration attorney is promote or independently tell an investor or potential client, this is the project where you should be investing. It usually happens where where a project may say to you, this is an investor, they don't have an immigration attorney and they need an immigration attorney. Would you handle it? I think that's usually where you see this kind of dual representation, usually with investors, with immigration attorneys. But again, Michael said, if you had a client, you have a project that you represent, would never tell them, oh, this is a project that you should be investing in. That would be far too much of a conflict.
I think dual representation can be done. It's extremely common in the EB-5 world, only because projects, regional centers typically have immigration attorneys that are filing their paperwork because, they themselves, the regional centers, are USCIS approved entities. At my practice, I only represent investors just because that's what I choose to do. I've worked at firms that have done both and have done both well. I tend to think it's simpler. I like working with clients and investors. 100% that's what I like to do. But just to echo what Ron and Michael said, 100% it's a red flag if your attorney is sort of limiting the projects you're looking at, if they're pushing one over the other because of a relationship they may have with them. And that's a question to ask a potential immigration attorney is, have you filed paperwork for that project? What is your relationship with them? And those are very simple questions that any attorney should be able to answer.
I would also mention that in the post-RIA period, so 2022 and onwards, there's been kind of like a reset of a lot of the rules and a shakeup of the landscape too. So in the past, there was this argument to say, well, if you have a dual representative, somebody who's intimately familiar with project, and they're also bringing on board the investor, then there's some gain of efficiency in there. I would say that in this current landscape, it is also very common and very doable for an investor to have their own attorney who is not involved in the creation of the regional center or the certification of the regional center or otherwise on the project side. A project worth its salt and worth its experience is going to have its own counsel that will communicate with your independent investors counsel, so that two lawyers are talking to each other and so that your lawyer is rapidly made aware of all developments and all information. So I would say that there isn't really much of an information lag or an information gap as far as having a dedicated investor side attorney and a dedicated project side attorney. And then just in a one in however many astronomical chance that something does go wrong and the interests of investor and project are no longer perfectly aligned, then you can still continue with your legal counsel knowing that there's no conflict of interest.
Yeah, I want to I agree with what Ben said. Unlike in the marriage case scenario where it would be very unusual for the husband and wife to have their own attorney, in the EB-5 case, it is not unusual, exactly, for the investor to have an attorney that is totally separate and different from the project. And if you are looking at a project or the regional center and they tell you they have an attorney, you are not in any way required to use their attorney. And if they insist, that would be a red flag right there.
Is there a certain point before working with an agent, working with a regional center, that you should be working with an immigration attorney What's the timeline for when you should start retaining these professionals?
I personally think it could, I think it makes sense to get started, relatively early in the process. Once you've decided that you're going to pursue it, most attorneys will tell you we can do both source of funds review and you can look at projects in parallel. I think that's the most efficient way to do things. I also totally understand when investors say, I want to pick my project, I want to be sure that the project makes sense for me, that it's safe, and then I'll start doing source of funds with you. I understand that because they don't want to, pay a legal retainer to get working on something. The only issue with that is that source of funds can take time. Depending on source of funds, it can take anywhere from 2 weeks to 6 weeks to put together, depending on how quickly, we look through documents, how quickly the client provides documents. And if you wait all that time while you're looking at a project and then decide to start source of funds, your application filing is going to be delayed. And I think that's particularly important for investors from China, from India, from Vietnam that have been subject to wait lists, that will likely be subject to wait lists in the future. When you file your I-526 petition, that creates your priority date. That is your place in any future visa waiting line. And so, most attorneys won't charge their whole fee up front. They'll charge a retainer to get started on source of funds. If for any reason, you don't pursue the process, you may be entitled to some of those funds back, depending on the engagement agreement you signed, depending on how much work you've already done. So I really think, if you're going to do it, at least getting started on source of funds and uploading documents and having the attorney look at those will save you a lot of time while you're looking at the project in parallel.
Now, I would add some projects want the investors to get confirmation from their attorneys that their sources and path of funds are suitable or well documented. And so it's important, I think, to get that advice from your attorney if there are gaps in the path, if you can't connect the dots between everything. It could take time to do that, especially when we're treating this, I think, in a semi-forensic analysis here that has to be really carefully mapped out.
And it is also possible at that early stage when you've discussed the source of funds and you know the universe of what documents are available, what are not, and might become available in future. Your attorney can also talk with you about likely USCIS response, likely USCIS request for further evidence. And then in some cases, the investor can even decide, let's go ahead and file with these if the attorney feels that this is a strong enough case, and then I will obtain these documents in case there is a future RFE. You don't necessarily need to reinvent the wheel for every single step, but just to know what the general outline of the future roadmap is going to be and what specifically you need is very helpful.
Yeah, if you don't have your source of funds ready, sometimes you might lose out on the project too, because there are limited spots within any particular project. And if it's going to take a long time to put your source of funds together, you may select your project, and then by the time you have your source of funds, because you're not ready to submit or make your investment because you're not ready, the project position might be gone. But the other thing is you want to work with your attorney early on because even identifying your source of funds, your attorney can help you do that, because they're going to want to identify what is the most straightforward, simplest one that is going to hopefully limit the possibility of questions from the Immigration Service, going to be the most straightforward in terms of source of funds and path of funds. And what I've seen from experience is if you don't work with your client early on, sometimes when they are trying to put together their funds, they may have so many transfers and so many complications that it would have been so much better if they'd been working with you early on, because you could have made it much more streamlined. And fortunately, the end result is because they didn't work with you, what you have to show to the Immigration Service and is going to end up creating a lot more questions than it would have, let's put it that way. So working with your attorney early on can usually streamline the process, because the attorney can advise you to do it in certain ways that hopefully will minimize potential questions from the Immigration Service.
In EB-5, as in everywhere else, prevention is so much better than cure. And sometimes the details that your attorney needs to know from you can be surprisingly innocuous. One other dimension that investors may want to consider, even at the preliminary interview with their potential lawyers, is to talk about even innocuous scheduling issues. It doesn't have to be something as grand as criminal history or Communist Party membership. I did have anecdotally one investor who was an F1 student in the US, and at the time that he was seeking to make his investment, he was actually physically in Hong Kong, back at home on vacation. And so he was ready to go. Let's go file, and get myself an early priority date. And then I asked him, what is your F1 visa and when are you coming back? He told me a certain date. And I informed him that if he waits until after the date he enters the US on that non-immigrant F1 visa, it would reduce the number of questions that could be asked at the border. And so he became aware of the possible risks, the possible obstacles, and also the possible gain. And he came to a decision on his own. Yes, let's delay a few days. It's not gonna kill the investment. So even little innocuous details, your life schedule, your attorney can work around that, but you do have to tell them.
Yeah, that's a good point. Definitely corresponding with your lawyer to be tactical about when you opt into EB-5 is definitely a good way to go about things. So I have one final question when we're talking about retaining an attorney when you're just opting into EB-5 for the first time. A lot of people wonder, how casually can I contact my attorney? Is it always a formal process? I know that when we had mentioned boutique firms the first time, we talked a little bit about how when it's a smaller firm, usually you can just reach out through a text or an email. Is that something that you guys see across the board? Is there merits to a more formal communication over informal? And what do you usually see with your own clients?
I think clients want quick feedback. They want quick communication. I think there's definitely merits to, a good formal email when you're discussing something that's complicated. You want everything to be spelled out. Well, I wouldn't, send my client a text message or a WhatsApp message if we're discussing, multiple paths of source of funds or what we're going to do, what kind of documents we need when we're looking at a sale of real estate. But I'm on WhatsApp. I've been on WhatsApp, ever since I started traveling abroad for EB-5, and most of my clients appreciate it. I don't answer text every minute, but I'm able to get back to my client very quickly with a quick message, or at least confirm that I received the message and say, hey, I'll message you back later this evening or tomorrow morning. If they have a quick question about, something I emailed them, I'm able to write back to them in real time, as opposed to getting back to my desk and sending a more formal email, when I can do something on the go. So I think a lot of lawyers, especially EB-5, they do that. Clients that are around the world, we'll be asking them questions at different hours of the night. So having something like that, like a WhatsApp or a WeChat, is very common. But yeah, so I think it's important. But I think there are merits to more formal communication, and obviously having quick contact with your client is important. So that's something to look for.
So, I use WhatsApp to communicate definitely initially too, because most clients are outside of the United States and I'm here in the US. And so that is the way to oftentimes initiate communications. But when it comes to anything formal, anything that involves documents, definitely email. The WhatsApp is really more for, especially if they're traveling, if there's a way, if we need to communicate, if we're having conversations, we talk by WhatsApp, we do everything like that. But for sending information, for anything that's not critical or time, email.
Right. But for example, if I had a relatively simple question, just seeking legal advice or, some guidance, or even just asking how's it going? Do you usually respond to your clients with that, or does that require a more formal meeting?
It depends, Izzy. I use WhatsApp. I sometimes, will have to, let someone know this might be better dealt with in a consultation setting, formally setting up a time. A simple question, is not always easy. I've had friends reach out to me on Facebook and say, I have a simple question, and they wanted to get married to someone and have a prenup and wanted to know whether or not that was going to be complicated in terms of the financial obligation. So I'm like, this is pretty complicated. There's bar articles written on this. So what I do with clients, of course, I'm happy to use WhatsApp and other communication means like Teams or Zoom, is I give all of our clients a special link that they can calendar with me on my webpage, on my firm's webpage, that they can schedule anytime they want a consult, time with me. I think scheduling is the best thing always to try to do. If there's an emergency and someone is stuck at the border or at the airport, WhatsApp is great. If it's not a life or death emergency, then let's try to set up a time. But there is more flexibility for boutique lawyers like us to be able to adapt to that when necessary.
Yes, and I also would sing the praises of the secure certificates with emails over chat programs. For some markets, this can be a bit of a cultural barrier to get over. There are certain markets where email is perhaps as antiquated as telegraph or Morse code. But I will take general questions from people who are generally interested, like simple questions, like genuinely simple questions by WhatsApp or WeChat, sometimes with a WeChat direct call or the equivalent of FaceTime. But regardless of what was discussed, I'll follow up by email so that there is this formal record of what was said. And whenever it gets to something confidential or something personal out of the general sphere and into the individual unique sphere of that particular inquirer, then I would move it to email. And sometimes I've gotten pushback from this. People are saying, oh, do I really have to open up my QQ account and send you an email from QQ? Yes, I'm sorry. This is how American lawyers operate.
So the next thing we want to talk about is how will my immigration attorney help with my EB-5 process? So what is essentially the role of the immigration attorney in helping with the immigration process? And how should people prepare for that first consultation when they are speaking with their retained immigration attorney?
For the EB-5 rule, it's going to be source of funds. That's one of the main things. It's the burden of the investor to provide those documents. So that's what you're going to discuss even on your initial call before you retain the attorney. So understanding what potential source of funds, avenues you have to explore, where the funds may come from, knowing what documents are available, what aren't, I think that's helpful for an initial call. So your attorney can develop a tailored checklist, provide a roadmap for you in terms of what documents you're going to want to gather, in the coming weeks. And then, I also think it's important to discuss past immigration issues if you've had any, discuss your family, and any problems you've had immigration-wise, your children have had immigration-wise, because the immigration rule is interconnected. And so just because you're pursuing EB-5 doesn't mean that issues that popped up in the past on a tourist visa or in your F1 status or H1B status, those can all have an effect on your future admissibility. So just being honest, forthright with your attorney, answering questionnaires as completely as possible, I think is really, really important and does save time at the end.
Usually I find the initial consultation is an opportunity to answer the questions that the client might have, or I guess potential client might have. Oftentimes they generally know the process by the time they've contacted you, but at the same time, you usually spend that really going over what the EB-5 process is, the three parts, the filing of the I-526 or I-526E, and what that entails, then the consular processing or adjustment of status for the next stage once the 526 or 526E is approved. And then, of course, the final stage after 2 years of conditional residency to remove conditions, the filing of the 829. When you go over the process, and then you get into sort of more the nitty gritty a little bit in terms of, the first stage, which is, the sourcing of funds, and they'll ask about projects and you tell them sort of your role and what you can do and what won't do and what you're, in terms of selecting a project and how you might, help them in terms of reviewing particular projects that they might select and give them advice in terms of investment brokers and things like that. And of course, there's going to be questions about fees and all of that. And, you go over it. We do talk, usually in the initial might talk a little bit about source of funds. I don't usually get into the nitty gritty because, it'll be more general about what are your general sources of funds. And we get into a little bit of discussion about that. Oftentimes there's usually a second and then we start talking about retaining, but attorney.
Yeah, for source of funds, which is the primary focus from the investor side and the attorney at the I-526 stage, that first stage of the EB-5 process, is going to be very thorough. It's probably not going to be on the level of a financial audit, but it's not far off. And U.S. immigration can ask for documents that you would expect to see for lawfully sourced funds. So eventually, you're going to have to get in that. An attorney might not necessarily get into that at the very first stage, but they will need to know broad brushstrokes. How are we going to reach that $800,000 minimum amount or 1.05 million amount? And how are we going to structure that? Where is it coming from? Are there other family members or friends who are donating money to you, because they will also need sources of funds as well. So it is not possible for an investor to say, well, this is coming from my father, therefore I'm showing nothing. Nothing needs to be shown. No, the father needs to be ready and able and willing to work with the attorney to disclose their documentation too. Aside from the source of funds, I would also say, and we've mentioned this once or twice before, let the attorney know your entire circumstantial, contextual situation. Let them know if you have children who are nearing the age of 21, or maybe even not nearing the age of 21, maybe children who are 10 years away from 21, because depending on your nation of origin, that may matter. Let them know if you're doing this primarily for yourself or if you're doing this primarily for your kids, because it may be possible for you to just give the money to your children and have them be the investor. Most dramatically, I had one potential investor who had a criminal history, and it was decades ago, and he was reformed and had all the documentation from the government proving that he was reformed, and he had patents, technological patents as well. And at the very first consultation, we established that was the case, and we then decided this man will not be the investor, his wife will be the investor, because the wife would then get a green card, could then use the basis of that green card to waive in her husband afterwards. Had that not come up at the very start, the entire thing would have been dead in the water a couple of years later at the consular processing stage. So please, please, please be honest with your attorney. Your communications with them are confidential and privileged, and it's important to have a good, accurate game plan and grand strategy starting off. I cannot stress that enough.
One perspective I want to add is, and I agree with everything that others are doing here, from screening investors to trying to screen their sources of funds, to understand where they might be coming from, to ask your clients to please be transparent with you, to not hold back on the information regarding how your funds were acquired or how your family earned those funds. Those are very important things that you don't want to wait several years to find out. But a lot of the clients that we see here in South Florida, many from South America, of course, I represent clients all over the world. I've represented clients from, I think, from every single hemisphere, every single continent. But a lot of clients are coming to me considering doing a direct or standalone investment. And sometimes they don't understand really the complexities that are involved with it. They really, and some clients are really adamant that's what they want to do. And a lot of clients really just don't understand how the EB-5 program works and what options might be available. So that's something, what I take a lot of pride in is really trying to educate the investors. Some of them might be looking at other projects and trying to go over what makes a project at least a good project, from job creation methodologies, from how economic forecasts are prepared in terms of the jobs that are created, because not all jobs are created equal. So I like to really go through a process of educating my clients about the timelines, about their strategies, about whether they're here in the US or not in the US. If they're not in the United States, it can become difficult. If they're going to consider trying to come into the country and apply for a green card, I think there's a lot of risks in doing that. But some clients are considering that. There's no way you can really dissuade them from doing it, but they need to carefully understand those risks. So understanding the risks of the EB-5 process is something that I try to go over with my clients so that they understand that the relationship they have with me will be one that we're really trying to educate them to really know a lot about how EB-5 works.
Can you talk a little bit about aging out and why the age of your children is so important when you are having these initial consultations with an attorney?
Sure. I mean, the age out, there are age out protections under law, specifically the Child Status Protection Act, which says that when you file your I-526 petition or I-526 petition, which is the starting point of when the EB-5 process is done, if you're not filing concurrently for the green card at the same time, you do have the ability to lock in your child's age by the time of filing your 526 petition, provided they're unmarried, they're under the age of 21. During the time that the process is pending, their age, while the 526 is processing, and if they haven't filed concurrently for their green card, their children's age is frozen in time. But once the petition is approved, their age becomes unfrozen after the petition is approved, and then they have 1 year to seek to acquire their permanent residence. this becomes critical if a waiting line has emerged for the investor and they haven't been able to apply for their green card to seek to, for their residence, perhaps concurrently. Then if they're overseas, the child's age is now counting forward from the time it was frozen. So if the waiting lines are very long in the EB-5 process, again in the future, because right now they are not for the new set aside reserve visas. You have to prepare your investors if they're from one of those countries that might have a forecasted waiting time, that they might want to consider other options if they run into a long line.
If a visa is not currently available, right, in a person's category in the EB-5, and they've been approved the 526, then the child's age, they continue to age, in other words. So if they're 18 years old when the 526 is approved, and 3 years later, in their visa category, EB-5, the visa is not available, they're now 21, and they have now aged out, is really what has happened. And that's a real problem if the person is from India or if the person is from China, which are right now are the two countries that you're seeing these really extensive wait times. And could be other countries. You might see it Vietnam. We saw it historically, sort of back and forth, and that is a major problem because I've had clients where their children have aged out for no reason other than the fact that out of at one point when they applied, visas were current, but by the time the 526 was approved and they were in a position where they could have applied for a visa, suddenly their category wasn't current, visas were not available, and they had to wait. And they waited and they waited, and their children aged out. And that's a really unfortunate situation. But usually, outside of those two countries, but of course that's because that's the greatest demand. Usually once you apply, the age for your child freezes the moment you file the 526 petition. They don't age for immigration purposes till the 526 is approved. So if it takes immigration years to approve it, it's not a problem. It's once the 526 is approved, and then whether or not the visa is available, that's the critical time period after the 526 is approved and if there's a visa available. And you don't know, that's the condition.
And to give an idea of the numerical complexity of what's going on, we know how many visas are allotted for the EB-5 categories, and we know the numerical breakdowns, but the quotas are administered on an annual basis. The online travel status, waiting lists and priority cutoff dates are updated on a monthly basis, and these visas cannot be consumed until the 526s have been approved. And as Michael mentioned, post-RIA, they were only really accepting the I-526s about halfway through 2022. And the processing, we're now looking at a situation where there's quite a few cases in the pipeline, but they have not yet been approved just because the review process takes time and they need to properly review them and approve the ones that are worthy of being approved. We're expecting that there's going to be a significant development of waiting lists. People are not quite sure exactly when it's going to appear, and a lot will depend on whether USCIS increases the speed or remains at the same predicted speed of processing these 526s. So if it sounds like there's many moving parts and many unknown variables, it's because there are. AIIA is actually planning on having a tool on their site, which is going to take as many of these variables as possible and let you, the investor, play around with these dials and levers and different scales and kind of try to estimate what we might see. There are also FOIA requests of the US government by many different parties trying to get a closer look at the inner workings of these processings. So hopefully the information gap will narrow and we'll know more. But if it sounds like there's a lot of uncertainty, it's because there's multiple different government departments working at multiple different speeds and then different sets of rules that apply to each one about the Childhood Status Protection Act.
One thing that kind of games the system, so to speak, doesn't really, is if you're in a position to adjust status. Right now, yeah. So right now, if you're physically in the United States on a visa, usually, in a H-1B or F student visa, but if we're talking now about aging out, so let's say you're here with a family and you invest in a set aside or in a visa category right now, which says it is current under the visa bulletin. Even though we don't know once your 526 petition is going to be approved what the status will be, it doesn't matter Because if you are here now in the United States, at the time you file your 526, you can file adjustment of status for yourself and your entire family. The filing of the adjustment of status freezes the age. And USCIS has said, and the State Department has concurred, that we are going to give the child age, they're going to freeze the age based on whatever the date is of the date of filing.
So, I mean, there are an incredible amount of moving parts, as we were saying earlier, when you're just beginning this process. We're thinking of aging out, you're thinking of source of funds. What else should an investor consider when they are filing their I-526? What things should they be preparing for their attorney? What can make this process a little bit smoother for everyone when the filing process is starting?
I think just, most attorneys, and what I like to do is just prepare a detailed, document checklist for biographic documents, immigration documents, and source of funds documents based on the initial, conversations we've had. I'll set up a Dropbox or Google Drive, something secure for to upload documents and reviewing them. And, obviously tax records, your financial records, those are going to be source of funds documents that are probably, going to be pertinent. At the same time, you're going to be working, looking at your project documents, working on selecting an investment if you're working with a broker dealer or whichever your financial advisor you're working with. So, I think staying organized and asking questions. I think it's, sometimes my client, can I ask you a question? Or they chat me, what do you think? It's absolutely. And I think the more questions you ask about the process, that gives us more information, that we may need. And it's our job to ask you questions. But if you have questions too, I think just having that open line of communication is really, really, really important during document gathering and preparing the case.
I would say, just as a general rule of thumb, and of course, circumstances will always vary because there's going to be several discrete categories of strategies. But the main challenge is to prove lawful source of funds. And when we're trying to prove lawfulness, attorneys love to see documents that come from a bank, that come from a government tax bureau, that comes from a certified financial institution. So for investors who are considering moving something to the tune of $800,000 out of their country, documentation that comes from these organizations, keep them handy. Don't throw them out. You may not need them. It might be overkill, but it's better to have it and not need it than to need it and not have it.
I always like to tell my clients to make sure that they preserve their records. When they file, if there's something that maybe they didn't give to me, download everything from your bank, from your accounts. All those records are available usually for 5 or 7 years in most jurisdictions and countries. And so you want to make sure you keep those records. It may be quite a lot to submit every bank statement from the last 7 years, but go ahead and download it now. Take those steps. There's a lot of things you can do proactively to make sure that you have those records. If the government asks for the kitchen sink later on, we need to be able to send it to them. So you do want to I think, have your attorney collect as much as you can. We're trying to show that it's more likely than not that your sources of funds were lawfully earned and acquired. But if the government tries to obtain more and several years have gone by, you don't want to lose those records. So I would say just make sure you really are diligent in your record keeping as an investor, because we can't just, most attorneys don't get into their investors' financial, accounts directly.
Yeah. I basically tell my clients, look, if I don't understand the path of funds, if I don't understand the source of funds, you need to assume that USCIS does not. So, we sit there and we walk it through and we talk it through and I go through it. And once I have all the documents, I let them know I'm going to go through everything myself and know and assume there's going to be more follow-up questions, because I will break it down, go through every document, and then come back with more questions. So there usually will be, and my view is, it's got to be at the level of a 5th grader. I hope USCIS is not watching this, but the idea is, is the explanation, is the understanding at the level? And honestly, that's not a fun. I'm not getting RFEs. Please draw a picture. Literally, the RFE from USCIS is draw a picture. We would like a diagram. We want to understand. They're not getting it. This is the adjudicator. We're attorneys. We've been doing this for how many years? These are individuals who've had maybe 6 weeks of training with a chart, a checklist. That is the adjudicator. So after all this work, we put together and we submit all of the documents that we submit for source of funds, will be stacks and stacks. You're sending years and years of bank accounts and taxes, and and you're tracing it, and then the adjudicator who gets it has had 6 weeks of training and has a checklist that they go through, and that's it. So it isn't surprising that oftentimes they don't understand. I got a recent RFE where it's clear they don't even understand the order of the transfer or that the money left the country, like the foreign country. It's pretty kind of amazing how simplistic you have to make the explanation. So to my clients, I actually let them know, by the end of this, you're going to hate me. You're really not going to like me, because I am going to, the level of detail that I am going to get to in terms of, the documents I'm going to ask for, the information, the questions, but it's not because I really am asking it for me. I know what the Immigration Service is going to want. And my goal is to really, I don't usually get RFPs. It's unusual. We don't want to. But to the extent that we do, we want to make sure that immigration gets what they need. I understand that, because you want this approved. It's just for you.
Many clients, come to me and they think, well, it's in my, I have my tax returns that shows that I reported the income, everything is fine. Isn't that enough? Well, maybe in other countries' citizenship programs, it might be enough, but not this agency. They really want to see the money, almost, the pay stubs. They want to see the money leaving your bank account to then be transferred to purchase your real estate, and then showing everything coming and going. It's a major, paper push, and because we have to file everything via paper, I joke that I'm a paper pusher. Really, that's what I do. I sell paper, and sell a lot of it. Although we're starting to be able to, soon to be able to electronically file these petitions, we still deal with paper. And one tip to clients is that if they have digital records that are downloaded from the bank, it makes things a lot easier rather than scanning everything.
For sure. And that electronic filing process is going to make everything a lot easier. So you won't have to move those reams of paper from one place to another.
I will believe it when I say it. They tried it before. That didn't go over well, if you guys remember. I don't know.
I don't trust it.
It didn't. And
yeah,
well, you know what they say,
they
second time's a charm, right?
To do the filing, if you remember. They wanted the clients to do it, and yet we as attorneys couldn't even advise our clients how to do it, because there was no process for us to get in to see what the clients were doing.
I also like to warn clients that sometimes the cost of translations might be close to what they're paying their attorney. Sometimes I've seen quotes. We can't exactly talk about what we might charge as attorneys in a public forum, but I've seen quotes from translation companies that are easily $15,000 just for translations. It's quite expensive. So there are some different options, but you have to, clients need to understand that there are costs, the government filing fees that are thousands of dollars and slated to maybe go up eventually. So it's there are a lot of time-consuming things. If you don't speak the native language, or even if you do, it's hard to go through a document that's not in English sometimes, without the translation. So it's just a lot easier to have that translation prepared, and that might be important to get started with your attorney sooner, so that they can start to review that, get those translations made, so that they can prepare your filing.
Okay, so when we're talking about an approved I-526, we're past that stage in the process. We're moving towards consular processing for investors who are living outside the US. What should they expect, and how do you prepare them for the consular processing procedure, and also subsequently the visa interview?
Well, I always send my clients just a visa guide that I've created. I send them questionnaires and information to help collect information for the DS-260 forms. Every consulate has a bit of a different procedure in terms of how to register, where to do your medical exam, et cetera, et cetera. Fortunately, every consulate has a pretty detailed summary of what to expect after the DS-260 forms have been filed, and the case is now with the consulate. So I prepare a package that I send to them. We review it. We fill out questionnaires, and we file the consular processing documents. And then at the EB-5 interview level, I always have a prep session with my clients. I prepare a, sort of a short memo that, refreshes their memories on source of funds, on the project they invested in. Every consulate's a little bit different. Mumbai, Guangzhou, consulates in Vietnam have a lot of experience with EB-5. There's some consulates that have very little experience with EB-5. And so I've had clients who have told me that the interviewer was, rehashing source of funds, was asking very difficult project questions that aren't incredibly relevant, or essentially trying to re-adjudicate the case, which isn't their job. And so I try to, keep my clients calm, but prepare them as best as they can in terms of being able to answer straightforward questions about what they did, usually 2, 3, 4 years before. And so there's a significant review and interview prep process, I find.
One thing that all the consulates at the interview stage usually always ask for is confirmation of the investment has been sustained. And given that's many years, so you usually always have to get some confirmation from the if it's a regional center project, whether it's usually they'll give you the K1s, your client might have them or they didn't receive them, but so you have to usually contact the project or the regional center to get that information, just to make sure that they have that for their interview. Some consulates I've found, especially recently, Singapore wanted the entire 526 package, and they wanted that delivered in paper, by hand, that happened after COVID. When they reopened and started doing interviews, I had multiple clients where they had to print out their entire 526 filing, everything, source of funds, project documents, print them out and deliver them to the consulate. That was fun, unexpected. So you start learning again. As Dennis said, every consulate's a little bit different, but pretty much they always have to get confirmation documents showing that they've sustained the investment. But then make sure your client always has that, and as I said, otherwise prep them in general. Make sure they're ready for whatever questions. Sometimes it's 2 minutes, sometimes it's a 20 minute. You don't know the interview's going to be.
I concur with everyone. We prepare a sort of a brief memorandum that goes over what they should do or not do, do's and don'ts for their interview. We always immediately, after we file, we always provide our clients it's a very much a digital project, a product that we prepare. In addition to the scan of everything, we create a very intricately prepared digital document that allows our clients to go through every single exhibit really easily, hundreds of exhibits at times. And we encourage our clients to go through that document, to review it beforehand, to review the memorandum specifically, to review the entire, we have a table of exhibits, a very detailed table of exhibits we prepare that gives our clients a roadmap of where everything is. When they're reviewing that, we want them to understand the nature of what they invested in, to remind themselves of what they did. And having that documentation is very important. We've received inquiries from consulates that say, or the clients, are told to them that well, the attorney didn't provide anything to the embassy. Well, it's supposed to be transmitted to them through the government, and that's not usually a requirement to provide an entire copy of everything there. But if that's needed, we've had consulates that have just simply given us links to upload documents to them, or to share it some other way through an email when necessary. But yeah, our clients do need to be aware, remember where their sources of funds came from. It should hopefully be somewhat second nature to them, but several years go by and they do want to review that.
That's very, very good points. At its most benign stage, the consular process should be a situation where the officer is looking at the folder they've already received and then asking questions of the client to make sure that their answers match what was in the 526, and then perhaps some update questions. For example, how have the funds been spent? Have you already committed all the funds to the project? How is the project going? And that sort of thing. I was placed outside the Guangzhou consulate, which at that time was the most busy EB-5 immigrant visa office worldwide, for about 3 years. And during that time, I've seen that sometimes the consular officers do not ask they do not limit the scope of the questions to what the process is expecting. And in situations like that, it is important more than ever, not just to have kind of like a pro forma, here's a checklist of things for you to memorize, and also a phone call or a Zoom call with your attorney to have a mock interview, but also to let the attorney know if anything has changed. Many times between the 526 and the consular process, family members may have grown in number or may have decreased in number. Family commitments may have changed, and you may have one spouse who wants to stay where they are and continue with their work, and another spouse wants to come to America, or certain children want to stay behind. And that also is something that the attorney needs to know. Strange outliers sometimes that consular post has been known to throw at people. If you have a familiar attorney, one who has done Chinese Communist Party obstacle, overcoming that obstacle of admissibility, that would increase your chances. And sometimes, much as the USCIS officer adjudicating your first petition may not have the specialized knowledge that you, an entrepreneur investor, might have, the same thing may go for the consular processing officer. We even had one consular processing officer who decided on their own that an F1 student's out of status situation constituted unlawful presence. And this was several years ago when there was a very clear distinction between these two concepts. And so then there had to be an emergency convocation, and we then had to work through with very persuasive legal arguments that this is the correct way to adjudicate the case, and this person should properly be given their EB-5 visa. Luckily, in that situation, we did prevail, but you sometimes cannot predict what the consular officer will throw at you. And if you have a lawyer who's been there and seen that and recognizes the elephant, that can help.
Complexity. How is the adjustment of status procedure? Is it slightly less complex? Is it because they're already in the US? Does that make the process a bit easier for the attorney and for the investor in terms of providing the information?
It can create different issues for you if someone hasn't arrived in the right status, for example, or if they're, it really depends. But the adjustment status is a little bit more direct, if you will. Some people call it that, versus waiting for the embassy to process everything for you. You don't have to go through the embassy and then go through CBP to get your admission and then get your green card mailed to you. You're really dealing with all the three major agencies when you're doing it through the embassy, but adjustment is more direct. And if it's an option that you can take, and you're willing to wait in the United States because you might be unable to travel once you apply in the United States to adjust. So you need to consider those things.
Yeah, one thing I would add is just, for individuals that may be running out of status, whether it's F1, you may have been laid off from your H-1B, if you're in your grace period of sorts, and whether it's F1 or H-1B, adjustment of status does give you the ability to stay in the U.S. as both Ron and Michael mentioned. You will have a work permit. You will have the ability to travel eventually. There's even situations where you could have time out of status, which is essentially forgiven, given based on certain sort of quirks in the law that will allow you to do so if you apply for adjustment of status. So it is beneficial in that sense for individuals in the U.S. The timelines can vary greatly depending on the processing center. There was a long period of time where consular processing was a quicker option. That changed with COVID and certain consulates, really slowing down processing. But normally for individuals who are in the States, adjustment of status is just going to be a benefit and also provide certain people with a backup status of sorts.
And then also it bears mentioning here, this is temporary, of course, but the post-RIA rules do say that if you are filing an I-526 or I-526E, and if you're in the US already, and if there's no waiting list for your nation of birth, you may also concurrently file the I-485 adjustment of status. So if you're coming up on close to the end of your non-immigrant status, like an H-1B or an L-1A, that properly filed adjustment of status allows you to remain in the US until it has been fully adjudicated. And that goes even if your I-526 is still pending. And that is a greatly beneficial change to the RIA, and that also does not apply for consular processing. So if you file your 526, you cannot simultaneously consular process. If a waiting list later develops for your nation of birth, you will then have to satisfy that waiting list as well before you can even begin the immigrant visa process at consular process. So the adjustment status, I think, is very helpful for families who have children who might be nearing the age out level, and you might want to consider that as an option to keep the family together inside America.
One thing to keep in mind, if the primary investor is consular processing, family members cannot adjust status until the primary investor has obtained their immigrant status. So, and also, even if everybody's consular processing, the primary investor has to first enter the United States, or they have to come together. Essentially, the person who is the investor must obtain their conditional residency at the same time or before anybody else can get their residency based on that same.
Yeah, that's a good clarification, because I feel like usually we do have investors who will ask us, you know, my child is on an F1 in the US, like, can't they adjust their status and, you know, get, instead of transferring to a green card or having to do OPT for a year, like, can they have their.
Not until you get your green card, basically.
Exactly.
If you're the investor, yeah.
Mm-hmm. Let's say we pass the consular processing stage, our adjustment of status is fully adjusted, and we're in the conditional green card period. What do investors need to take into account before filing the I-829, and what can they expect from that process?
I think, you know, your attorney should be contacting you before the 90-day filing window opens. You know, I typically, you know, I set timers or, you know, calendar reminders for all my clients as to when, you know, I want to be contacting them, usually, to be honest, 3 months before the 90-day window starts, just to let them know what's coming down, coming down the pipe. A lot of my clients will be in contact with me before then, because they're getting ready to file it. They want to file it. A lot of the documentation that we include comes from the project. You have to confirm sustainment of the investment. You have to confirm job creation at the 829 stage. So if you're invested with a regional center project, those documents, those templates are going to be coming from the regional center. There are certain documents you may want to include in your I-829 petition, depending on your individual circumstances. You know, one thing I always recommend, you know, to tell my clients is that even when you're a permanent resident, you know, you can still have admissibilities. You can still, you know, lose your residence because of criminal problems, because of other issues. You're not a U.S. citizen just yet, and so these issues could come up at the 829 stage. And the conditional residency period can be long at some, you know, during certain periods of time. So things can happen. And so I think it's important to be forthright with your immigration attorney when you're pursuing the 829 process, because these issues can slow down the process. And again, it's a long process generally. One more thing I'd mention is that when you file the 829, your residence is extended indefinitely during the entire period of adjudication of the 829. So while you will get a receipt notice that extends your conditional green card for a certain duration, I believe now it's up to 48 months, and that document is also going to be used for travel. Even if you were to lose that document, and you need to request a new one, the law says that you are a resident until that 829 is adjudicated, and even in certain circumstances further outwards. So once that 829 is filed, your conditional residence is extended during the duration of the period of time when it's adjudicated.
I'd like to add that the before you file the 829, you want your attorney to make sure that not only have the jobs been created, but there might be some simple ways to confirm that the funds were sustained. Make sure that the accounting records that you're provided, the tax records that you're provided as an investor, do not demonstrate that some money has been returned to you at any stage. It also depends upon, based on the RIA, when you filed. For new investors that are filing today, the investment needs to be sustained for at least no less than 2 years. At the time of filing the 829, if that has been met, there might be some, you know, different rules that will come into play later on to determine, you know, how long that money needed to stay 100% at risk without going back to you. But generally, if the accounting looks right, if the funds have stayed sustained, deployed fully to the project, or redeployed somewhere else if that was required, then the 829 you should be able to file it. Of course, you have to file it within that 90-day period, or you will get into immigration court, and then you have to file it late, and then you'll be married to the immigration judge for many years while you're waiting for it to come through. But other than that, once the 829 is filed, depending on the project and of course the policy, which currently says that you don't need to be fully invested at the time of filing the 829, you might consider asking your project whether or not you can exit at that time and seek a return of your capital. So those are some things that we do let our clients know, even though it's an investment decision. The investor does need to be aware of what the immigration rules say if they are considering that they need to make that capital withdrawal from the project.
And just to follow on, certainly for the regional center program participation, the 829, much of the money has gone to the regional center. So much of the documentation is going to be from the regional center tracking that money. The primary points that I've seen 829 investors themselves have to take point for and prove are that they've complied with the rules of the lawful permanent residency. So being physically present in America for a certain amount of time each year is very important. Maintaining ties, maintaining that narrative of showing to the US government, yes, I live here because you gave me a green card and that's for me to live here and for me to start my new life here. So working with your attorney, that also builds a narrative. There's kind of a narrative writing that has to be built and a context built. One final thing that Dennis touched upon also is that during this time, you're still removable. So it is possible for criminal activities to affect your ability to succeed at the 829 stage. And one part that's still a little controversial and that you'll need to talk with your attorney about is that not all liberties are treated equally everywhere. Legal regimens can be different from state to state or from city to city. And especially apparent certain states have made controlled substances legal or decriminalize them. It's important to bear in mind that USCIS goes by federal laws, and they'll look to federal laws and compare state laws and often pick whichever one is more strict. And if they find one violation of one, even if the same activity is not a violation of the other, that could also endanger lawful permanent residency. So that's something to keep in mind as well and talk with your attorney.
So my next question is a little bit contentious, but as attorneys, it would be great to hear your advice on this. So what should an investor do if they're having problems with their current attorney? Is there a potential for them to switch attorneys midway through their immigration process? Will that have an impact on their immigration process? What are their options?
So you can 100% change your attorney. It's very clear in U.S. ethics, legal ethics, that you have the right to change your attorney. Your attorney represents you. And I've had clients tell me in their home country that it's very difficult to change attorneys. And I've had clients come to me that are currently engaged, by one attorney and say, my attorney's not picking up the phone, he's not answering my emails. And I think that's probably the most common complaint that I get, is that the lack of communication makes, the process very difficult. And, people get busy, but, responding to clients, and we have a duty to communicate with our clients on a timely basis. So you can 100% change attorneys. In terms of disrupting the process, no, it shouldn't and it won't. It's very simple. It's to change attorneys from a legal perspective. In terms of updating USCIS, that can be done by paper and online. I always do both. And USCIS typically responds rather quickly to an update. When you update the G28, it's the attorney's job to notify the regional center. To confirm, there's a new, attorney of record, that correspondence from the regional center should also be copied to the attorney. But it's a simple process. It's not something, to be afraid of. If there's obligations you still have to your previous attorney in terms of fees, that's something that the contract will dictate. But 100%, it's your right to be able to change attorneys, and you need to be working with somebody. You want to be working with someone that communicates with you, that best represents you and your family, and that you feel comfortable with. So that's what I would say.
And the EB-5 process is also a process of several discrete and distinct phases too. So an investor who has gone in with one attorney representation for, say, the entire 3-phase or even 4-phase portion, if they've already achieved 1 or 2 phases, they could then contract with another attorney to sort of say, all right, well, we're now doing just the follow-up phases, and potentially expect that reasonable fees would be lower because there's less work to be done too. And that also is a discussion that, as Dennis said, the engagement agreement with the initial attorney would control how much refund, if any, gets sent back. It might be worth looking at the engagement agreement and seeing if they've broken down the fees by phase so that they're reserving the money set aside so it can be returned to the investor if the later phases are not doable or do not want to be done with that attorney. You may also want to look at the engagement agreement and see what happens for a phase that's partially completed, where the lawyer has done some work, but then for whatever reason, procedural or otherwise, the work does not get completed. Some attorneys may have switch to an hourly rate for phases that are partially completed but not completable in full. So these are just various portions structurally you can look at the contract between you and your attorney.
Fantastic. Yeah, and that's great advice to know for many investors who might be having issues or, feel like their attorney may not have the experience they need or so forth. So on a similar point, what happens if something goes wrong with a project? How does the immigration attorney help them prepare for worst case scenarios in terms of investment, in terms of immigration? The job creation maybe isn't all there. What does the immigration attorney do to sort of help them prepare?
In the past, if a project didn't work out, first of all, we're not investment advisors. It's hard for us to make the demands to demand someone's money back. An attorney can tell you, hey, I might recommend that you seek litigation counsel if that's what's necessary. But there are new changes to the law based on the AIIA that provide new protections to investors that we didn't have before, that give us some different options and different hope if something does go wrong. If something happens to the regional center, but the project is fine, we can move the project to a new regional center. Or if the project just does something improper, there might be, and if the investor gets their money back, the investor might have to file a new petition and preserve their basis in the program. So the options are different. Your attorney can help you walk through those types of options, or argue that there was job creation that, if necessary, through the different stages of the EB-5 process, if there is that type of challenge.
One thing that's very, very unique about EB-5, first of all, it is unfortunate. We've had in the past, and probably will have in the future, projects that have gone bad, where investors have not been able to show the job creation that is necessary, where their 829s have been denied even. And in that situation, technically they are deportable, let's say, right? They can be put into removal proceedings, or they find themselves in limbo. But what is unique is that you remain, if you're in that situation, you're EB-5, you remain a conditional resident. You don't lose your residency. There's a moment where you technically, if the 829 is denied, you actually lose your residency for that moment, but you are entitled to get your residency back, to get evidence that you are still a conditional resident, and you remain a conditional resident up until there is a final order of removal, which is a very long process that can take years and years, because you can appeal it and go on for a long, long time. And it may never happen, because if the Immigration Service doesn't file a notice for you to appear in immigration proceedings, which very often doesn't, you may never find yourself in that proceeding. So there are individuals here in the United States who unfortunately found themselves in a project that went bad, that are still in the United States as conditional residents and have never lost their residency, even though the 829 was not approved. It is not an ideal situation to be in. It's actually terrible, because you're in limbo and you're always going to be conditional residents. But your residents, you can still travel, you can still work, you have technically all of the rights and privileges of permanent residents in the United States, except you don't have a green card that is unconditional, that proves that you're a resident, and you cannot apply for citizenship. And you just have to constantly, every year, get a stamp in your passport, which is the I-551 stamp showing. And unfortunately, you also usually have to prove to the Immigration Service, over and over, that you're entitled to the status, but you are. So it's a terrible position to be in, and anytime you're in a position that you can find a way to fix it, or to get a new status, or as Michael said, under the new law, which they still don't act, there are ways that you can maybe switch to a different product. They are trying, there needs to be better legislation to help investors, and hopefully, AIIA can work to do that, because that is something that I am pretty passionate about. I've had investors, unfortunately, in different, there have been some huge projects that have gotten a lot of press, who have found themselves in that situation. But we have worked, and we've made sure that the investors that have been in there have not lost their residency, and they maintain their status, and they continue to live here in the United States. But yeah, it needs to be better. We need to do better. The industry needs to fight harder to make sure that investors in that situation have avenues, because they are the ones who have been hurt the most, and the legislation needs to reflect that they are innocent and need to have avenues to protect them.
Sure. Investors definitely have the most to lose in this process financially, and especially in terms of their immigration process, putting off their family planning. Like there are too many sad stories of investors who have waited for years and years and years to bring their kids to the US, to educate them here, and then things have fallen through at the end of it.
We've been here for 10 plus years. Their children basically have become American. They've lived here since they were children, and now this has happened. And I think regional centers and projects that work in this and are using the project, the program to get financing, need to understand, and I make this clear whenever I'm talking, you are dealing with people's lives. It's not just about the money and the funding, or people, when you come through the EB-5 program, it is a visa. You're bringing your whole family, moving your life here. And so when you're getting funding from that, that's important consideration. And I think, projects that do that, regional centers that work in this industry, need to understand that. And hopefully most of them do, and respect that, and know that that's what you're doing when it is not just about the financing.
And also just to revisit the concept of a project going bad, there are multiple different layers where this might manifest. And certainly we're talking about, as we are, risk-averse attorneys, we're talking about the worst possible outcome. But with proper legal representation, there are other intermediate levels of outcome where a certain degree of give and take may be possible too. For example, losing some or all of the investment principal may not be fatal to the petition if the job creation is accomplished. Or perhaps if the entire project doesn't create all of the jobs that it intended to, if there's some shortfall in jobs, there may also be an argument made for whichever level of priority that a given investor in the dozen or hundreds of investor stack should enjoy when being apportioned the 10 job creations. So it may be possible to pull some victory from the jaws of defeat, at least from the immigration viewpoint, in those situations. So that is where an attorney who's familiar with the 829 and post 829 landscape rules can be worth their weight of their legal fee, at least.
So to round out this discussion, and thank you guys for being so diligent with your responses, I'd love to get your opinions on where investors can look for other resources besides this video, maybe outside of AIIA, maybe inside. What are some resources that these investors should be looking at before they opt into EB-5? Where else can they get info on the process and best practices and so forth?
Like you guys.
Yeah,
you guys actually have a really great library of resources. No, you really do. I mean, obviously we're talking for you guys whenever, but your resources page has some pretty great.
Yeah. I strongly agree. The industry has many established groups that are very informational groups to represent the EB-5 legal industry and attorneys and their message to Congress and to rulemakers, and also from the regional center side and project side as well. And now we have a strong movement towards securing the interests and rights of investors, EB-5 investors, the engines of the job creating opportunities through this category. I think that's very important. Previously, we had mentioned AILA, AILA, the American Immigration Lawyers Association. They are very active with EB-5 seminars, both to educate attorneys and also to educate investors and other parties to the entire structure. And then, of course, at a basic minimum, I would encourage people to check out the USCIS policy manual. Although it is still being added to, it is already a significant increase in transparency from how the USCIS used to operate, where there was one policy memorandum from 2013 that everybody had to memorize and just go off of that. So kudos to the USCIS for also increasing access to their adjudication and to their categories as well.
Okay, well, fantastic. Thank you guys for sticking with us and giving such robust responses to these questions. I hope that this gives everyone who watches this video a much better understanding of how to go about seeking out an immigration attorney.
Well, that was certainly an interesting conversation, and there was a lot that was said, but we hope you learned something that you didn't know before you had watched this video. For more information about the EB-5 program and what we're doing to protect the rights of EB-5 investors, please visit our website at goaii.org. AIIA.org. We have a flourishing blog that is regularly updated. We have tons of resources for both current and prospective investors. And we also post about what we're doing in the political sphere all the time. So be sure to keep in touch, and we'll see you later.